Yes, Bhumika, another 1 second. Now you can very well start.
Sure, sir. Greetings to all. BSK Legal.
एक सेकंड रुकना मैं बोल रहा
1
हूँ.
second. Yeah, you
So
can.
it has been started.
Yeah, please start, Bhumika.
Greetings to all. BSK Legal, a very renowned and reputed law firm dealing in insurance law, commercial criminal arbitration, and many other law fields in collaboration with Briefcase, Legal Intellect, and Law Orchid, is proud to organize this webinar on the topic RTI, Law Pillar of Democracy. For this session, we have with us our learned guest, Mr. Wajahat Habibullah, who was the chairperson of the National Commission for Minorities. Prior to this, he also held the position of Chief Information Commissioner of India. He was an officer of the Indian Administrative Service from 1968 till his retirement in 2005. And he was also the Secretary of the Government of India in the Ministry of Panchayati Raj. He's been awarded with numerous awards like the Rajiv Gandhi Award for Excellence in Secularism and the Gold Medal for Distinguished Services, and Governor of Jammu and Kashmir, Lal Ram Mohan History Award as well. We also have with us learned advocate Mr. Sanjay K Chadha, who is the founding and managing partner in the litigation and arbitration compliance group of firm BSK Legal. His area of practice is diverse from labor laws to commercial disputes and many other intellectual property rights and other dynamic fields of law. Under his supervision at present, the firm is successfully handling cases in over 614 districts throughout the length and breadth of the country. He is a very renowned and well-established face in various media channels. And with the objective of spreading awareness amongst the youth, he regularly conducts various webinars and sessions along with the numerous internship programs for the law students to impart the dynamics of law as a subject. Over to you, sir.
Thank you very much, Bhumika. It's first of all, I would like to welcome one of my favorite officer of this country. The correct word would be thumb of this country, Dr. and very honorable Wajahat Habibullah Sahab. I'm also very happy to say that I have got with me a very prominent political scientist of this country, Dr. Vipin Kumar Malhotra, who's popularly known as Vipin K. Malhotra in Delhi University, and a very big name. I remember, he was the college topper, university topper in Hindu college way back in our times. I welcome both of you from core of my heart. Sir, we have got a lot of students, and I could see here in YouTube, which is the main platform where we are live right now. We have a great number, and it is increasing second by second. Today, we are, and that I would owe that is your charisma, sir, your name. So I would begin with because a lot of law students are there, I would like to just give a little introduction about the subject and give them a legal what exactly is what we are going to talk, and how you are the one who was the first established this big statue, and then you have shown this has become a reality for the country. So the topic today is RTI, Pillar of Democracy. It was on October 12th, if I'm not wrong, 2005. This dynamic act was passed, which has, in its true sense, given the strength to the masses, to strength to the people. I would say that in 2005, with the avtaran of RTI Act, a practical regime to right to information for the citizen, to secure access to the public access to the information which is in control of public authority, was given. Each and every citizen was given this right, this adhikar, as we call it, and with the utmost principle of transparency and accountability in public working of public authority. So that is a very, very landmark thing which had happened. We know in Sweden, way back, this such law was there. From where we have seen that in the Western world, etc., this is already existing. And there was a long pending demand to which all of us, people like you has also pressurized, and this came into existence. Now, as far as the democracy is concerned, by the people, of the people, for the people, as we all know, we are the biggest democracy of the world. And one of some Western very renowned person has said that for a successful and vibrant democracy, it is necessary that the citizen should be informed citizen. And this is what I feel this act has done. And, it has brought in the new regime of transparency of information, which is as per the, whatever we know. If a informed citizen is there, then only he can ask question from the government or from the authority of the, or that why this is happening, why this is not happening, or all those things. And what I feel is that in its real sense, the democracy is now working under, with these last 15 years, as far as this particular phenomena is concerned. So there are many aspects, but this has good governance, inclusive democracy, tracking or, curbing corruption. All these were the main objectives of this act, which to a great extent, as far as if we see from the lens of the lens of the act, this has achieved. Now, this is the background. For the knowledge of my students as well as some of the lawyers, I would like to also mention here certain provisions, certain important provisions of RTI. And then I will touch base certain case laws where in a very short time, because everybody is waiting to hear our honorable guest. So as far as the key provisions of this act are concerned, 2005 Act, one is Section 6, which provides in what format you have to, what all informations you can acquire from a public authority, and what should be the format. All those things are provided in Section 6 of the Act. Section 7 is such a important provision of this Act, which says that the information has to be responded within a specific time frame. You have to respond to the information within the given time. 30 days is the time within which you have to inform. There is one, if there is a question of life and liberty, then the answer has to be given within 48 hours. So that is the beauty. And if nobody gives the answer, you can straight away go and file an appeal under Section 19. You can go and file an appeal about it, that the information was desired, information was not provided. That means I can go and it will be taken as if an order is passed and no information is given. There are certain exceptions also provided in Section 8. So we should also know that in case we have to, the law restrict, you can not, it is not something straight, you can go whatever you want, you will get. No, it is like this, that like some exceptions I can give you. The examples of sovereignty and integrity of the country, if something is expressly prohibited by the court, privileges of the parliament, the friendly relations with the neighboring country, fiduciary relationship, husband, wife, girlfriend, agent, girlfriend, boyfriend, agent, master fiduciary relationship, and many more are there specifically mentioned in section 8, which one should know. And section 9 specifically provides then when the information pertains to a third party, what will be the procedure? They have to give a notice to the other party, and then that procedure is also there. And as I said earlier, the provision of appeal within time frame or wrong document is supplied or anything, then you can file an appeal. And for everything, a period is provided, which is the beautiful thing. Now, if I wanted to quote one more provision, then I come to the cases for my students. 4 or 5 cases I would like to discuss here. The most important provision is provision of section 20, which says that in case the information is not provided within the time frame, there will be a provision for putting penalty on the person. Public authority has to be, the person who is responsible to furnish the information will be fined for 250 rupees per day to the extent of 25,000 rupees maximum. Similarly, if you have a right for a information, there is correlated duty, section 4, I think, which is obligation on the part of the public authority to furnish. So these are the important key provisions which make this law and make it a strong law. That's what I feel. I would like to give you a few examples of various judgments passed by our constitutional courts. Like it was very difficult to have, if you want to have the copy of FIR, you were earlier not able to do. In the case of one state of Kerala case, I think Jiju versus state of Kerala. In that case, it was decided by the court that within 48 hours, such application that FIR has to be handed over, has to be given. This is the law of land now. Similarly, people wanting to know some information about some company. So how they can do that? The Subhash Bhan versus state of Maharashtra is the case wherein it was held that ROC has to provide. It is duty, obligation on the part of ROC to provide the information. The judgment of Bal Krishna Porwal versus PIO is another very landmark judgment, wherein it was decided that if a person needs some information for proving himself to be innocent, then like what had happened in this case, that he said that somebody has given evidence against you. You can't ask for that. So the court said, why can't? Because it's a question of my liberty. And to that principle of it is right to life. Right to life means right to live with dignity. So it is very much allowed. Even somebody has given evidence, you have to provide that evidence to that particular individual so that he can counter it. So, and in this Balkrishna case, even a penalty of 25,000 was imposed for not giving the document. Similarly, you can't refuse somebody, Om Prakash case, you can't refuse somebody the information saying that the file is not traceable. It is your headache. How you do? File is missing. We can't provide the information. No, it is not permitted. Similarly, these days very active also CBSC. Vijay Kumar case was there. Vijay Kumar versus CBSC, where in the father had asked for the copies of the son. What he has written, he wanted to see. The court said, yes, you have to give. IIT, I remember, I think during the time of Sir only, this judgment was given. Why can't you give the copy? You have to rather give also the answer sheet, that this is the right answer. If in this manner the answer is written, this much marks will be given. That also you have to provide. I think it was a judgment of Sir only, if I'm not wrong. But it was there during Sir's time only. I would come back to, the regime has expanded also. I wanted to say this. A recent judgment, 2019 judgment, where our own Supreme Court, 5-bench judges, has said that CJI's office is also within the ambit of RTI. It falls within the ambit of RTI. It has said that, yes, CJI's office is a public authority. That judgment is also very relevant. So similarly, in that judgment, it was said that certain restrictions were certainly there, like the right to privacy. Even that is very important. Right to privacy. In that judgment, one line I wanted to, I just recollected that in that judgment, it was stated that right to information and right to privacy both are, two sides of a coin. So that kind of balance you have to do. You have to see that RTI doesn't become an instrument of surveillance. This is what the Supreme Court has said. So this dynamic law, of course, it was stated by the Supreme Court that judicial independence is utmost, sarvopari. It is the top priority. But certainly rights of persons, an informed citizen is strong. Who can, if I don't have information, how can I question anybody? With this act, even today, a rickshaw wala can ask Delhi University how much you are funding, what is the expenses Delhi University has in R&D, what you are doing in this department, how much you are spending, what are the aids given, what, a villager can ask from his block development officer, what is the expenses in, and when this road was made, how much was the expenses, everything. So transparency. So this is the biggest thing which this law has given. And I feel that this law has given a big instrument in the hands of our citizens. And of course, as I said in the beginning, I was mentioning about Sweden. Even today, there a lot more has to be done. In the transparency index, world transparency index, we are at number 51, I think. The Sweden is at number 1. So that transparency we have to achieve. Lot more is to be done, but certainly a lot is done, I must say. And who better than our own guest today will explain it, who was the first CIC of this country, who established this instrument in the entire country successfully. He served for I think the largest number of years he has served. So without wasting much of the time, I think whatever small I was able to explain to my students, that this is what is the law as far as the legal proposition is concerned. And the law is, as we all know, law is dynamic. It is developing day by day. There is no doubt about it. And now I would request our honorable guest today to please throw some light on the entire subject and how this is growing, how and what happened when you were establishing it, what all you faced. Please share with us today. Thank you very much, sir, and most welcome to you once again, sir. Sir, I think you have to unmute your mic.
Sorry about that. Sanjay ji, Bhumika ji, can you hear me now?
Yes, yes.
Okay. Friends, guests, a warm welcome to you for this evening of discussion on the right to information. Sanjay ji, you have, I think, lucidly put in the framework of the law and described its importance. The question that I want to put to you at the end of what I will present to you is that, are we actually using to our benefit as citizens of this country the full power and strength of this law? Now, the source of this law. You mentioned, of course, that Sweden was a country which brought this law. But most of these laws, the right to information as a movement, is really a 20th century movement. It's only in 1966 that the US came up with this Freedom of Information Act, on which our own act is modeled. Our own act is, of course, much better than that. But you are perfectly right in saying that it is this law which India has for long been recognized as the world's largest democracy. But this law makes India also the world's foremost democracy. But that is provided, and we have a host of laws to ensure and consolidate our democratic structure. The question is, are we doing enough to use these laws to make democracy real? Not only for ourselves, but for the poorest of the poor, which takes us back to Mahatma Gandhi, who defined the Swaraj in these terms. The real Swaraj will come not by the acquisition of authority by a few, because भारतवासी बन जाएंगे सरकार और अंग्रेजों को निकाल देंगे, उससे स्वराज हो जाएगा. But the real Swaraj will come not by that, but by the acquisition of capacity by all to resist authority when abused. हम में ये शक्ति आनी चाहिए कि अगर हमारी सरकार इस लकीर से हटना शुरू हो जाए, तो we can resist such moves by those in authority. And therefore, those in authority does not only simply mean the question of those in government. It is a much wider ramification. And let me bring in another illustration. This is from the father of our nation. But far away across the world from the other side, when Barack Hussein Obama became president of the United States, his first address to the administration of the US on the 21st of January 2009, he said, a democracy requires accountability, and accountability requires transparency. आप सबको ये पता है कि जो हमारी सरकार है इस समय, the BJP was elected to authority on the grounds of ensuring transparency and accountability, and has carried forward on that. Now you may argue, and you have every right to argue, whether it is carried forward enough, whether Man Ki Baat is adequate, but the fact is that they have taken steps in that direction. So as stated by the President of the United States, that accountability and transparency are essential to a democracy. So we in India also have accepted this idea that transparency and accountability are fundamental to our accountability. As Justice Louis Brandeis wrote, according to President Obama, sunlight is said to be the best of disinfectants. In our democracy, talking of his own democracy, the Freedom of Information Act, which encourages accountability through transparency, is the most prominent expression of a profound national commitment to ensuring an open government. This sentence is important, which I will read out to you now. At the heart of that commitment is the idea that accountability is in the interest of the government and the citizenry alike. But this is not something, it's not a weapon. एक हमारे हाथ में एक हथियार नहीं है, with which we can attack the government. It is an instrument which is in our interest as a government, which is in our interest as a people. It is, in short, a means of the government and the people working together, which, as you will agree, is the actual essence of a democracy. What is a democracy? A democracy is where people participate in governance to make harmonious functioning of administration in cooperation between government and public. What is inclusive governance then? Now, for example, in today's world, earlier, building infrastructure was considered the monopoly of the government. Okay? You have privatization. You have electricity generated by private organization. Not only in Bombay, as it has always been, but also in Delhi. Employment. Is this the job of government alone? In this, the people have to work together with government. And therefore, the people have to ask the question that has our employment been growing? The government can provide facilities like the government has attempted to do through NREGA. But are the figures of employment growth adequate? Then there's health. Health is something when we go in for voting and go and put in our vote, we expect the government to do something basically for our health and education. Now, our country can be proud of the fact that we have some of the best hospitals in the world. People from across the world will not get that kind of medical facility for the kind of price that we offer. And that is why our hospitals are considered, our top hospitals are considered best in the world. But are all our hospitals achieving that level? We have the highest network of hospitals of anywhere in the world. Primary health centers in every village, in every panchayat. But are health facilities available to all our people? Education. Again, wide expanse of education across the country. IITs, which you mentioned, the top educational institutions of their kind in the whole world, whose alumni are coveted by MNCs from leading countries. But is that kind of education accessible to everyone? You do know. Studies have shown the quality of our education, of India's education, does not even compare with other countries who we consider less in Africa, who we consider less developed in India. Center-state fiscal relations. To the center and the state, the constitutional guarantees fiscal relations for all sides. Is that being actually implemented? Government has taken a major step in this, in promoting center-state financial relations. GST. But is GST functioning in the way that it is supposed to? And here, you can see from the time when Mr. Arun Jaitley was revenue minister, how much he was depending upon the returns from public information to improve the GST. You remember when GST was first launched, it was on very insecure grounds, and there was a lot of criticism. But that criticism was responded to. The government took it into account in making changes in the GST system. Some people have said too many changes, but whatever. This is a way in which the government is being able to, or seeks to improve its performance in the public eye. Public-private partnership. Now, public-private partnership is very much a part of the right to information. Although previous Prime Minister Dr. Manmohan Singh, when talking at one of the national conventions of the RTI, and mentioned that public-private partnership has taken certain institutions outside pale of the RTI. Then I spoke to him afterwards. I said, no, sir. They have brought those institutions to the private institutions earlier outside the pale of RTI, and by participating with government or taking over institutions which is formed by legislation of government or parliament, they have also become public authority. Access to justice. The rise of Panchayati Raj. How are these symptoms of inclusive governance. I spend more time in that as we go along. Then there's the question which concerns us all of national security versus social security. Where does individual freedom come here? And the right to information is nothing more than a guarantee of individual freedom. So, is individual freedom in contravention of national security? No. And the RTI gives you that information, that answer. Why? Because what is the nation? The nation is all of us, the people. भूमि तो है, किंतु भूमि का प्रयोग हमें करना है भाई. We the people constitute the nation. Our security, our common security, of course, there may be some of us who are trying to work against others, but the security of the Indian people, the Indian population, is national security. And I think right to information brings this factor home. There are 4 imperatives of leadership in a democracy. And this I have taken from 7 habits of highly effective people by the great management expert Stephen Covey of the US. The first is to inspire trust. आप नेता नहीं हो सकते अगर लोगों को आप पे भरोसा नहीं. So I think you will agree with me. The first imperative of a leader is one who commands trust. The second is to clarify purpose. We must know what is the leader trying to do? Where is he trying to lead us? Is he simply playing an instrument and leading us in a dance? Or is he working towards something he wants to give to us? The third is to align systems. You know, a weakness of our government has been that different systems have not worked together. One ministry is doing one thing, another ministry is doing another thing. And I have found in my experiences working in the RTI as Chief Information Commissioner, that there were contradictory objectives of the same ministry under the same government. One department doing one thing, the other department working in a different direction. And the effect of the RTI was to make both the departments and ministries realize that what they're doing something wrong. And therefore, seek the order of the political authority to actually coordinate their function. You know that we have been criticized, our government has been criticized for a silo system, where if one arm of the government doesn't know what the other arm is doing. The answer to that obviously lies in the RTI. And the fourth is the fruit of the other 3, unleashing talent. As you probably rightly put it, Chadha, we cannot get our democracy to function unless we have the information. Once we have the information, then the talent, and I'm sure that among the people who are sitting and listening to me, there will be so many who will have that talent. That talent will be unleashed with the mastery of the information. Now, how did our country move towards this information revolution? I mentioned to you the ideal of Swaraj from the very beginning was the idea of a right to information. And this was, in fact, when Dr. Manmohan Singh was introducing the bill in Parliament in May 2005. That is what he said, that this will include, make the poorest man participate in government. But the information revolution took a long time in coming. It didn't come with the birth of our freedom without Christmas destiny. First, and this must be recognized, and this is also been held by the Supreme Court, the right to information is a fundamental right. Under Article 19(1)(a), freedom of speech and expression. And this has been held by the Supreme Court, so in front of all you lawyers, I don't have to expand on this point. But the demand for this started coming in when the government came up with this ambitious poverty alleviation program in the early 1980s, which has found that crores of rupees were being spent on poverty alleviation programs, but yet the levels of poverty were not coming down. They came down, of course, they came down from 50% to 20%, but were they coming down commensurate with the amount of money being spent on them? In other words, were the returns commensurate with the investment? And I think the consensus was that they were not. So the people themselves started asking this question. The people who were employed in poverty alleviation programs, they started asking questions. And that brought a revolution. At the same time, in the 1980s, you also had a revolution in information technology. As you will remember, in the time when Mr. Rajiv Gandhi became the Prime Minister, people were making fun of him and his young friends, that these are all computer whiz kids, they won't be able to run a government. But in fact, computer technology is what was the heart of information technology. And this started coming in the 1980s, which led to the withdrawal of government monopoly in information and broadcasting. Remember that up to the 1990s, Doordarshan was the only TV channel that we could see. All India Radio was the only radio channel for all of us. Now there are so many, all part of an information revolution. And as I mentioned to you, the workers started asking questions. And there were initiatives of civil society in Rajasthan. I'm emphasizing these points to emphasize for you the fact that the people of the country who brought about this legislation. Government's role was more or less reactive. The initiatives came from us, from the public, from the poor. And in Rajasthan, as you know, MKSS, my batchmate Aruna Roy, who was Aruna Jairam, when she joined the IAS with me, and of course she left the service to go and serve with the MKSS, then approached these people, asked these questions, and that brought about a media revolution, a free media, and the Freedom of Information Act came in 2002. I mentioned to you Mr. Arun Jaitley. At that time, he was law minister. He brought the first Freedom of Information Act in 2002, and then we had the Right to Information Act in 2005. Now, the Right to Information Act is what has brought about this revolution in our country. But the place where it was designed to actually have its roots, there are still inadequacies. Bhumika mentioned that I was also Secretary Panchayati Raj. In fact, I was first Chief Information Commissioner. I was also the first Secretary of the Ministry of Panchayati Raj in 2004. But at that time, of course, the Right to Information Act hadn't come into being. But the Right to Information Act, Panchayat should become a principal instrument of ensuring access to information across the rural areas of the country. You know that we have 3 levels of Panchayat. There is the Gram Panchayat, there are 540 of those. There's the Block Panchayat, 6,096 of those. The Village Panchayat, 2,40,000. Now, at the district panchayat level, they're settling development priorities, planning and monitoring, channelizing funds. As you know today, large numbers of funds are going through the panchayats for development at the rural level. the present government has been asking the senior government officials to go out to the villages and see how this money is being spent. I would not agree that is the best way. I would say, and I come back to that, the best way is to mobilize the panchayats to do their job. The block panchayats provides facilitation by aggregating technical and staff resources and capacity building. But the delivery of information and services all depends on the village panchayat. So the village panchayats can keep their people informed as to what are the services that are available, and so many services available from government, and give the government a feedback on what are the needs of the people. That, if I may say so, is the key to the successful implementation of the right. Now, this is the means through which it can function. The Gram Panchayat at the core, the citizens as a group receiving information from Panchayat with feedback from public and accountability, giving a feedback to the Panchayats and the citizens individuals also getting a feedback from the Panchayats and giving the Panchayat the individual requirements of the citizen. Gram Panchayat can collate this information, provided with inputs from government, that is scheme information, citizen surveys, fiscal information, over-the-counter services, certificates, taxation, billing, licenses, ration cards, all fed into the panchayats. And if the government provides that with the functions, funds, and functionaries to implement this, just imagine what a powerful source of good governance the panchayats could be. Have they become that yet? They have not. But these are the basics. And if I may now come to a quotation again, mentioned, of course, about what many people have said about Panchayati Raj. This is what Kofi Annan, the UN Secretary General, had to say about it. The great democratizing power of information has given us all the chance to effect change and alleviate poverty in ways we cannot even imagine today. Mind you, his emphasis is on poverty alleviation. I mentioned to you earlier the question of poverty alleviation in our country. Kofi Annan's view, without a feedback from India, is the main objective, the main task of freedom of information is the alleviation of poverty. Therefore, he says, our task, your task, is to make that change real for those in need, wherever they may be. With information on our side, with knowledge of a potential for all, the path to poverty can be reversed. In other words, and if you think about it, if you have information, you need not be poor. Reverting again to my earlier statement, that the government has schemes, has facilities designed especially for the poor. But are the poor availing of those? No. Are the people getting the benefits of those? They are not. It's all very well to accuse the government. You see, it's helping the richer people and all. The government has got the schemes for the poorest of the poor. It is we who are not availing of those schemes. There's also fault line in government, because government officials should be also going there, doing their job and explaining to people that these are schemes. Like I've said, they should be explaining to the panchayat that these are the schemes available. So government at that level is failing in its task. But if we realize our rights If we realize that we have the right to information, we can ask the government questions which the government will have to answer. And we will find our answers through that. Now, what is information? I think this is important. It is important to understand what exactly is information. This is defined in section 2(1) of the Act. Information means any material in any form, including records, documents, memos, emails, so on and so forth. But also, please note, this sentence, what it means is that information means any material in any form. But what does that mean? That means the material has to be held in some form. Information has to be in some material form. It's not that you are exercising, you are asking me to answer a question for which I have no information in any material form. I may have in any material form. I may have an idea. My wife may have told me about it. I may have overheard somebody talking about it. That is not information. Information means any material in any form. And therefore, I have held, as Chief Information Commissioner, that even the noting made by judges when they're hearing arguments, if that noting is actually preserved on file, if it's destroyed, then it's no longer material. And there's nothing to prohibit its being destroyed. But if it is held on file, it becomes information. It has to be provided. And I've decided many cases on that basis. Then also, the question that you had raised, Chadha, any private body which can be accessed by a public authority under any other law for the time being in force, by any other law, if it is answerable to any public authority, it itself becomes a public authority. And that is the way organizations like the Indian Olympic Association, Commonwealth Games Committee, all these were forced to disclose information regarding the conduct of things like Commonwealth Games and others, when initially they said that we are not prepared to give it, because all of them come under the purview of the RTI Act. And a number of private firms have now come under the RTI and are answering. Because in India, in our country, because of our socialist background, many of the laws, like the Companies Act, require even private companies to report things to government, like Education Act, require schools to provide a host of information regarding teachers and their backgrounds to government, even though the schools may be private. But any information which government has a right to access is information accessible under the Right to Information Act, under the principle that government is not simply those who are in the cabinet or inside government service. These are all appointees of the government. MPs are only representatives of the public. The public is in itself the government. You and I, Chadha, and all our listeners, we are the government, the true government. The others are all appointed by us to run the government. And therefore, information is ours. We choose who does what with the information that is ours. So the key concepts, if I may now begin sum up, the key concepts are transparency and accountability in the working of every public authority. The right of any citizen of India to request access to information and the corresponding duty of government to meet the request, except, as you mentioned, the exempted information under sections 88 and 24. Section 24 includes those organizations which are in Schedule 1, which are organizations which are engaged in intelligence work and other work, and therefore their information is not disclosable. And Section 8. But the beauty of Section 8 You must understand. And I discovered this when discussing our law with other international agencies, including the World Bank. The beauty of that is that it limits those items in which information cannot be given. And those items are specific. Many of them you mentioned. National security, national economy, so on and so forth. These are specific items in Section 8, 8.1 to J. Now, any other information, all other information is disclosable. So what it means is, unless the item you wish to keep secret is mentioned in Section 8, it is assumed it is not excluded and has to be given. You mentioned private information, and privacy and information being two sides of the same coin.
Yes.
Private information also is information where you respect privacy. That means it cannot be disclosed without the knowledge of the person to whom it is private information. But, for example, in the UK, the Data Protection Act protects private information. But it must also subscribe to Section 8. If it is not exempted information under Section 8, which of course exempts private information, then it cannot be treated as exempt. The government's duty is to proactively make available key information to all, and that is Section 4. And I'll come a little later to the beauty of Section 4, the merit of Section 4. But the sum total of what I'm saying is that this is a responsibility. The Right to Information Law places a responsibility on all sections, that is the citizenry, the NGOs, the media. Please understand, it is not only government. Government has a major responsibility because government is holding the information. But the responsibility of what information to are, how to use that information, this is the responsibility of the citizenry. It is the responsibility of the NGOs as to how they can bring about promotion, given the fact that large numbers of government-sponsored works are now being implemented by NGOs. How best to implement them? The NGOs must know how government wishes them to be implemented, but also how the people require them to be implemented. That's all part of the right to information. Media. Because if the media is not active, then how do any of us know what to ask for? It is the media who must keep us alert, the citizenry alert. The key player in this field is the Indian citizen, not the Indian government, the Indian citizen. And therefore, the responsibility of the Indian citizen is also not to befuddle the government with foolish questions and a host of questions, a host of petty questions of which he already knows the answer, in order to bog the government down in their work. But does that mean that we should work towards getting certain types of questions made decreed as mischievous and vexatious, as there is a law that vexatious applications are to be punishable under the law? I had recommended, and I had not supported any such amendment to our law, because I feel that this is a responsibility that the citizens have to take. If they find that one among them is moving vexatious application simply because he wants to harass the PIO, it is for him to say, please don't do this, because if you do this, then my time is being wasted. मैं और प्रश्न करना चाहता हूँ, मुझे और सूचना की आवश्यकता है, लेकिन आप ये एप्लीकेशन अपने देते रहते हैं और जो PIO है उसका सारा समय चला जाता है आपको उत्तर देते देते, और मेरा जो विशेष मेरी जो विशेष सूचना है जिससे लोगों की जान बच सकती है उसके लिए उनको टाइम. This becomes then a movement among the public, and already an instrument exists for that, and that is social audit. There is already social audit initiated again by my friend Aruna Roy. But then, what is the obligation of government, the principal obligation of government? And this is defined in section. Every public authority shall, and you are all students of law or lawyers yourselves, which of course means that you are also students of law. Every public authority shall, you know the meaning of that word,